Good evening, class. Tonight's lesson is Chapter 8, Unenforceable Contracts. So, we have already discussed in passing yung definition ng unenforceable contracts when we discussed the introduction to defective contracts. With respect to defective contracts, ito na yung malapit sa walang force and effect. Bakit ito malapit? Kasi pwede siyang magkaroon ng force and effect. Unlike in a void contract, never siyang magkakaroon ng force and effect. Ito, may chance. So, remember, in decreasing order, ito na yung pangatlo na defective contract bago yung pinakahuli na void contract. So, anyway, remember the definition of unenforceable contracts. They are valid contracts. Bakit siya valid? Because, again, merong cause, merong object, and merong consent. So, even if that is the case, it is a valid contract. Remember also na kahit na ganun siya, meron siyang essential elements, it is of no force and effect. Wala siyang force, wala siyang effect. Parang wala lang. There is a contract existing, but remember, wala siyang force, wala siyang effect. Now, the question in unenforceable contracts is, pwede bang magkaroon ng force and effect yung unenforceable contract? Yes, remember, if the contract is ratified. So, with respect to ratification, again, remember in rescissible contracts, hindi kailangang i-ratify. In voidable contracts, the injured party may or may not ratify yung voidable contract. And also in case of unenforceable contracts, the party, one of the contracting parties must ratify yung unenforceable contract so that it will have force and effect. So remember also, class, doon sa sense na yon, sabi ni Justice Paras doon sa kanyang book na Civil Code, in that sense, these contracts are also known as validable contracts. Doon lang sa sense na yon na wala silang effect ngayon, but later on, pwede silang magkaroon ng effect because of ratification. But remember also na talagang valid naman talaga sila kasi nandun lahat ng essential elements. Nanggugulo lang si Justice Reyes dyan. Anyway, also remember as a side note, right of third persons to assail unenforceable contracts. Can third persons question yung unenforceable contract? Hindi, syempre. Bakit? Kasi wala nga siyang force and effect. Paano mo pa siyang i-question? And besides, a stranger is not affected by a contract which has no force, which has no effect. So, no right to assail an unenforceable contract on the part of strangers or third persons. What else do you have to remember for unenforceable contracts? Kinds, tatlo. Ito na naman ako, nagmamadali na naman ako. May nag-comment kasi nagmamadali raw akong magsalita. Para 30 minutes lang yung video, kahit sa totoo lang, pagka dinidiscuss ko yan sa regular class ko, 1 hour, 1 and a half, depende kung nagpa-participate yung class. So anyway, kinds of unenforceable contracts. Number 1, contracts which are unauthorized. So anyway, we already discussed that in passing in Article 1317. We will discuss again later. Number 2, those which do not comply with the Statute of Frauds and Perjuries. So more commonly known as simply Statute of Frauds. Pero yun ang complete na pangalan niya, Statute of Frauds and Perjuries. What else? Number 3, those where both parties are incapable of giving consent to the contract. So remember, unenforceable yan if both parties are incapacitated. Again, if only one is incapacitated, it is a voidable contract. If both are incapacitated, it is an unenforceable contract. What if both are capacitated? Obviously, the contract is a valid contract provided, class, that hindi illegal ang object, hindi rin illegal ang cause. So what else, class? dun muna tayo sa unauthorized contracts. So, Articles 1317 in relation to 1403 and 1404. So, remember, unauthorized contracts are those entered in the name of another person. So, ang papasok sa kontrata is hindi yung may-ari ng property, hindi yung magre-render ng service, but a different person. So, yung taong yon, that different person will enter into a contract sa pangalan noong may-ari ng property or yung magre-render ng service, depending on what kind of contract it is. So, remember, itong taong to, who will enter into the contract in representation of another person, may not be authorized, or if that person is authorized, yung action ng person na yan, yung pumasok sa kontrata, is beyond his authority. So, magbigay na lang tayo ng example para madali. Ang isang unauthorized contract entered into in the name of another person is kapitbahay nyo. Binenta niya yung cellphone mo. O, di ba? Nagulat ka na lang, one day may kumakatok sa bahay ninyo, kinukuha na yung cellphone mo. Siya daw ang buyer. Pero syempre, hindi mo naman naalalang ibinenta mo yung cellphone mo. So, sinong nagbenta? Sabi mong ganon, yung kapitbahay ninyo. So, remember here, the kapitbahay entered into a contract with a third person, yung buyer, involving your property. And here, remember, the kapitbahay is not authorized to so enter into that contract. Wala siyang authority na ibenta yung cellphone mo. Actually, nagulat ka pa nga na binibili na yung cellphone mo at nandyan na yung buyer. Kesyo nabayaran na raw ng buyer, etc. etc. So, yun ay unauthorized contract. What about yung second part, yung second kind, yung one who has acted beyond his powers? So, almost same example. So, let's say, class, na itong si kapitbahay is really authorized to sell your cellphone. Sabi mo sa kapitbahay, benta mo nga tong cellphone ko, hanap mo ng buyer. Ganitong presyo, 500 pesos na cash. So, yun ang authority na binigay mo sa kapitbahay. To sell the cellphone, 500 pesos cash. So, remember now that the kapitbahay, the neighbor, is your agent. Now, ikaw naman yung principal na nagbigay ng authority dun sa agent. Now, let us say si agent, who is authorized to sell your cellphone, nakahanap siya ng buyer, binenta niya, he entered into a contract with the buyer, but sold the cellphone for 300 pesos and installment pa, 100. So, here, class, remember, although the agent is authorized, he exceeded his authority. Ano bang authority niya? Sell cellphone for 500 cash. So, yun ang dapat niyang sinunod. But here, remember, he sold at a lower price, which he is not allowed to do so, and also he sold in installment, which he is not allowed to do so. Now, with respect to you na may-ari ng cellphone, remember, this contract is not enforceable against you. So, kung pumunta yung buyer, wala kang obligation na i-recognize yung kanyang right, since hindi mo naman inauthorize yung kapitbahay, or in the second case, hindi yon ang authority na binigay mo dun sa kapitbahay. So, remember, unauthorized contracts. What else? Itong unauthorized contract na ba to pwedeng magkaroon ng force and effect? Siyempre, as long as it is ratified. So, if sino ang magra-ratify pala? That is the question. Siyempre, ikaw na may-ari ng cellphone. The person allegedly represented, or the person who gave authority actually, kung talagang inauthorize mo naman siya. Now, without ratification, yung agent, in quotes, remember, will assume personal liability. Also, what you have to remember here, ratification must be clear and express. Malinaw na itong owner ng cellphone is, as in our example, is really adopting yung defective contract entered into by the so-called agent. So the next kind of unenforceable contract are the contracts covered by the Statute of Frauds and Perjuries. So the Statute of Frauds and Perjuries has been enacted to prevent fraud and to prevent also honest mistake by requiring that certain agreements which are enumerated under the statute to be in writing. If not in writing, remember, they cannot be proven in court. So yun ang tandaan nyo sa Statute of Frauds. Yung mga naka-enumerate na mga agreement, kailangan may writing. Kung wala silang writing, you go to court, you cannot prove it. Kasi pagdating sa court, the court will require a written instrument. Wala ka nun. So remember, they are unenforceable also by court action because there is no way that the court will recognize yung verbal contract. What else? Number 2 that you have to remember about Statute of Frauds and Perjuries, they are ratified also. Pwede namang i-ratify yan kasi unenforceable contract yan eh. And ratification here consists in the failure to object to the presentation of oral evidence to prove the contract. So, nagpe-present na yung plaintiff ng verbal evidence sa court. Di ba bawal yon? Pero ikaw naman, na defendant, you do not object to the presentation of verbal evidence to prove the existence of the agreement. The agreement, so remember here that it is a waiver of the coverage of the Statute of Frauds, and number 2, by acceptance of the benefits under them. Anyway, we will discuss this more when we go to 1405. Also, remember, lastly, that the Statute of Frauds and Perjuries is a rule of exclusion. And later on, I will tell you also, I'm telling you now, that it is a defense available to the defendant. So, it is a rule of exclusion. Why? Because here, with respect to the agreements enumerated in the law, pwede mo sana silang i-prove by verbal evidence. May usapan talagang ganyan. Marami kang chismosang kapitbahay na nakarinig na pwede mo silang i-present sa court to be witnesses to the existence of the agreement. But remember, the statute excludes such kinds of evidence and will only admit yung evidence in writing or the written instrument which will reflect yung agreement of the parties. So remember, kung wala itong law na to, sana yung mga contracts na naka-enumerate sa statute pwedeng i-prove ng oral evidence. But because of this rule, which is a rule of exclusion, hindi pwede. Written lang ang tatanggapin ng court. Now, if you cannot prove the existence of your contract using written instruments, edi hindi pwedeng i-enforce yung contract. Also, as I've said before, it is a defense. Why? Because if you are the defendant or ikaw yung person against whom the contract is being enforced, or sa madaling salita, you are the person being made liable under the unenforceable contract. Defense mo to kasi pagka nagpe-present na sila na, kung wala talagang writing, kapag nagpe-present na yung plaintiff ng verbal evidence, because that is the only way to prove. Kung wala kang written evidence, verbal na lang, o nagpe-present na siya ng witnesses, ikaw naman na defendant, ay, bawal yan. Hindi pwede yung ganyang klase ng evidence. So, the Statute of Frauds is your defense. So, dahil nga hindi nila ma-present yung kanilang mga witnesses, kahit ilan pa yan, buong barangay, remember also na walang evidence na i-admit ang court because there is no writing. So, yun ang kailangan yung tandaan sa Statute of Frauds muna. Ano muna siya? Medyo ilagay nyo lang sa utak ninyo kasi actually yung Statute of Frauds, siya yung pinakamahirap na i-explain na concept. Pero pagka napunta na tayo sa mga examples and we will apply yung mga concepts na diniscuss ko kanina at saka yung i-discuss ko pa mamaya, yung mga rules, dun nyo siya maintindihan. Magsasama-sama sila. So anyway, also for Statute of Frauds, remember the rules of application. Ito yung sinasabi kong, in addition to the definition, you also have to learn this also. Pero ilagay nyo muna sa utak nyo, standby ninyo. Mamaya i-apply natin lahat yan. So number 1, the statute, letter A, the statute of frauds is not applicable in actions which are neither for damages because of a violation of the contract nor for specific performance thereof. Ang hirap ng pagkakasabi sa book ninyo, no? Para mas madali, the statute of frauds is applicable only to actions for damages or for specific performance. So there are only 2 instances when the statute of frauds will apply. Kapag ka manghihingi ka na lang ng damages kasi hindi natupad yung agreement, and also kung dinimanda ka for specific performance. I'm sure alam niyo naman yung specific performance dahil na-discuss na yan sa obligations pa lang. So, specific performance, go to court. The court will compel yung party to perform yung obligation. However, subject to limitations. Meron tayong mga obligations na hindi, kahit ang court, hindi nila pwedeng i-compel. So, personal obligations, obviously, hindi pwedeng i-compel yan. But, pwede namang manghingi ng damages in lieu of personal obligations. What else? Number 2, applicable only to executory contracts. So, remember your contracts, kinds of contracts according to status. Sinabi kong aralin nyo yan, nasa chapter 1 lang yan. So, executory contracts are contracts na wala pang nangyari. So, wala pang na-perform under the contract. Yun ang executory. Yung kabaliktaran niya is yung executed contract. So, here, there's already a full performance, full and satisfactory performance. Remember also that some contracts are partially executed. Ibig sabihin, there's performance on the side of one party, no performance on the side of another party. What else? Number letter C. It is not applicable where the contract is admitted expressly or impliedly. So, pagka inadmit naman yung agreement, which is verbal, hindi na siya nalalaglag sa statute of frauds. Inadmit kasi ng defendant that there is such an agreement, hindi na kailangang i-prove ng plaintiff yan. What else? It is applicable only to agreements enumerated therein, meaning the enumeration is exclusive. If it is not one of the agreements enumerated under the statute, hindi siya covered by the statute of frauds. What else? Letter E, not applicable where a writing does not express the true agreement of the parties. So here, class, this refers to relative simulation. So in relative simulation, remember, there is a real agreement. Ito yung disguised contracts. There is a real agreement. However, the written instrument is, or yung lumalabas nilang usapan is a different agreement. Kaya nga, disguised. So, remember, if the real agreement is not covered by the statute of frauds, hindi naman kailangan na in writing siya. So, yun ang tandaan nyo. What else? It does not declare the contracts infringing it as void, but merely unenforceable. So, remember, pagka nag-violate kayo ng statute of frauds, or remember na hindi naman void yung contract na yan. Kasi ang void contract, hindi mo siya pwedeng i-ratify. Pero unenforceable yan. Kasi ang mga contracts which violated the statute of frauds, pwede siyang ma-ratify. Katulad nga ng sinabi ko kanina in 1405, you can ratify contracts which infringe yung statute of frauds. And letter G, the defense is personal to the parties and cannot be interposed by strangers to the contract. Only the defendant can say that the agreement is covered by the statute of frauds. Personal sa kanya yung defense na yan. So the agreements covered by the statute of frauds and perjuries are: number 1, agreement that by its terms is not to be performed within 1 year from the making thereof. So for number 1, letter A, let us apply all the rules that we have studied a while ago. So the agreement in letter A is not to be performed within 1 year. So from the time of contracting, walang mangyayari hanggang sa next year. So pagka nag 1 year na, hindi pa siya na-perform. Ang performance here is sometime in the future after 1 year. So 1 year and 1 day, yan, pasok na yan sa statute of frauds. Anong ibig sabihin yan? Para maging enforceable itong mga agreement na to, na after 1 year ipe-perform, kailangan merong writing, kailangan merong some form of memorandum, etc., etc. In short, kailangan siyang nakasulat. Now, I will give you an example. So, let us say birthday mo, December 5. Yan, birthday mo yan. So, this year, ayaw mo maghanda actually kasi pandemic, nakakahiya naman. So, sabi mo, next year ka na lang maghahanda. Tapos, gusto mo, bongga yung birthday mo, gusto mo magkaroon ng birthday concert. Yan. So, kukuha ka ng magaling na singer sa katauhan ni Coco Martin. So, kinuha mo si Coco Martin kasi paborito mo yung kanyang hit song na Maybe This Time. So, anyway, pumunta ka sa Manila, kasama mo lahat ng mga kapitbahay mong chismoso at chismosa na gustong makita sa personal si Coco Martin. Anyway, nakita mo siya, nag-usap kayo, sabi mo, kanta ka nga sa birthday ko, sabi ni Coco. Sige ba? Sabi niya ganun. Tapos, kailan ba yung birthday mo? Next year, December 5. So, pumayag siya, natuwa ka, masaya kayong umuwi ng mga chismosa mong kapitbahay after yung taking ng pictures, etc., etc. So, anyway, pagkatapos nun, fast forward na natin. Fast forward to malapit na yung birthday mo. So, ang ginawa mo, ni-reserve mo yung gym, naglagay ka ng mga tarpaulins all over Tarlac City. Tapos, sabi mo, happy birthday to me. Birthday concert, guest star, Coco Martin. Tapos, December 5 at TSU Gym. Ayan, diba? Social. So, anyway, fast forward, mismong araw na ng birthday mo. So, nandun lahat ng mga kakilala mo. Yung mga chismoso at chismosa sa kanto, yung mga kaklase mo ng elementary, nung high school, nung college, yung mga ibang kabarangay mo pa, yung mga katrabaho mo, tsaka yung mga inggitera sa'yo. Ayan. Anyway, naghintay kayo para dumating si Coco Martin, tapos bigla, hindi siya dumating. O, di. Ang naramdaman mo? Nalungkot ka, napahiya ka, tumakbo ka sa backstage, tapos umiyak ka. Yan. Ngayon, pagkatapos mong umiyak, syempre, sabi mo, magdedemanda ako. Syempre, diba? Nakakahiya nga naman yun. So, kailangan mo talagang magdemanda just to vindicate your right or the embarrassment that you have suffered. So, anyway, ayan ka na. Nagdedemanda ka na. Remember, ang pwede mo lang i-file here is either an action for damages or an action for specific performance. Doon lang naman kasi nag-a-apply yung statute of frauds. So, pagka ang action is not, pagka ang action hindi siya specific performance or damages, hindi pinag-uusapan yung statute of frauds. It can be proven by the agreement can be proven by verbal evidence. But here, let us say, class, dahil hindi pwedeng specific performance, hindi mo naman pwedeng pilitin si Coco Martin na kumanta kung ayaw niya. Remember, this is against the Constitution. This is involuntary servitude. So, ang pwede mo lang hingin is damages. Yan. So, anyway, tapos na rin naman yung birthday mo eh. So, wala na rin siyang magagawa. Wala na rin magagawa. So, action for damages. Tapos, nag-hearing. Dumating si Coco Martin. May attorney siya. May attorney ka rin. So, anyway, syempre, wala kang evidence to prove yung agreement ninyo. So, naisip mo, sinong naisip nyo? Ang naisip nyo, I'm sure, is yung mga chismoso at chismosang kapitbahay. Yun ang purpose nila doon, kaya sila sumama. Anyway, kayang-kayang patunayan ng mga chismosan yung kapitbahay na meron nga namang usapan between you and Coco Martin. Because remember, the first obstacle to your case is to prove the existence of the contract. So here you go. Chismoso and chismosa. Ipe-present mo sila isa-isa sa witness stand so that they can prove the existence of the contract. So anyway, bigla nag-object yung attorney ni Coco Martin. Why? Because remember here that the contract is one of the contracts covered by the Statute of Frauds. Bakit po? Kasi it is an agreement which is not to be performed within a year. So in short, yung performance niya is after 1 year, and anong sabi ng statute? There must be some kind of writing or memorandum to evidence the agreement. So, itong attorney ni Coco Martin, sabi niya, ay, hindi po pwedeng mag-present ng testimony ng witnesses to prove the existence of a contract covered by the Statute of Frauds. What is allowed only is a written instrument. So remember, yung Statute of Frauds is a rule of exclusion. Mapapatunayan sana ng mga chismosang kapitbahay yung agreement, except that the statute excludes that kind of evidence. Remember, bawal ang verbal evidence, bawal ang oral testimony. If you will hear the term also parole evidence, this is the same as verbal evidence, oral evidence. So, bawal yan. Rule of exclusion. And also, that is the defense of Coco Martin. So, ngayon, dahil binawal yung mga witness ninyo, ano nang mangyayari sa'yo? Wala. Nganga ka. So, hindi ka lang napahiya nung birthday mo. Nung nagdemanda ka, napahiya ka rin ulit. Remember that. So, yun ang kailangan nating tandaan. The agreement is unenforceable because it was not in writing. You cannot prove it by verbal evidence. Number 2, same example, para lang malinaw ang application. What if, class? Same story, fast forward, nasa hearing na tayo uli. Except that, ito na naman yung attorney mo, pinipresent na naman yung mga chismoso at chismosan yung kapitbahay. Tapos, habang pinipresent sila, ito namang si attorney ni Coco Martin, even Coco Martin himself, did not object to the presentation of verbal evidence to prove the existence of a contract which is supposedly covered by the Statute of Frauds. Now, question, anong effect niyan? The effect is that, remember, the contract is ratified by failure to object. Yan. So, ngayon, dahil na-prove na nila yung contract, maaaring maging liable for damages si Coco Martin. Dahil na-prove ang existence ng contract, tapos hindi siya nagpunta, there is in fact a violation, breach of contract, liable for damages. The same is true if Coco Martin also admitted yung existence ng contract. At talagang may usapan na ganyan. Kaso lang, nakalimutan ko, hindi nila ako ni-remind. So, kasalanan nila. Malay nyo, ganun ang defense. So, in that case, remember, pwede pa rin siyang maging liable for damages. Because kahit hindi na i-prove yung contract, inadmit naman niya yung existence ng contract. So, again, admission of the existence of the contract ratifies yung contract and there is no need for further evidence. What else? Also, to add to the depth of knowledge, para alam nyo pang i-apply, dadagdagan ko pa. Same facts, except that, medyo magre-rewind ako ng konti. Except nung nagpunta kayo sa Manila, kasama yung mga chismoso at chismosa nyong, wait lang class, my battery is running low, I will plug my device first. Pause ko muna. Close. Now, to add to the discussion, another example is almost same example, except here, class, nung nagpunta kayo sa Manila, kasama yung mga chismoso at chismosan yung kapitbahay, nakita nila na ikaw ay nag-down payment para dun sa birthday concert na gagawin ni Coco Martin next year. So, they saw you, there is money involved, and also, let us say, merong resibo. Let us say, actually, kahit wala namang problema yun. So, anyway, fast forward to the future. So, TSU gym, fast forward tarpaulin, fast forward birthday mo, fast forward nalungkot, fast forward napahiya, fast forward pumunta sa backstage at umiyak, fast forward demanda, etc. etc. Tapos bigla nung nasa hearing na, nakita na meron palang payment. So you have proven payment. So now if you have proven payment, remember class, kahit na mag-object yung attorney ni Coco Martin, hindi na pwede. Why? Because here, the contract is partially executed. Why is it partially executed? Because there is performance on the part of one of the contracting parties. Remember, your down payment is partial performance. So, 300,000 down payment is partial performance. Now, also, partial performance removes the contract from the coverage of the statute of frauds. Even if it is to be performed after 1 year, if there is partial payment or partial execution, hindi na covered ng statute yan. And it can be proven by oral evidence. So, yun ang kailangan yung tandaan sa unenforceable contracts. Now, question, what if same example, except that balak mong mag-birthday concert hindi December 5, 2021, balak mong mag-birthday concert ng December 5, 2020. Siyempre, insensitive ka. So, gusto mo, kahit na may pandemic, magbe-birthday concert ka. So, anyway, same facts. Fast forward to malapit na yung December 5, 2020. Nung nag-usap pala kayo ni Coco Martin, by the way, wala kang binayad. As in, wala. Tapos, umuo si Coco Martin. Fast forward to malapit na yung December 5, 2020. Fast forward to TSU gym. Fast forward to tarpaulin. Fast forward to araw ng birthday mo. Fast forward to hindi siya dumating. Tapos, ikaw ay nalungkot, napahiya, and fast forward, tumakbo ka sa backstage at umiyak. Fast forward, nagdemanda ka, etc. etc. Now, question, habang pine-present mo yung iyong mga evidence, ay yung mga witnesses mo, yung mga chismoso at chismosa sa kanto na nakasaksi doon sa inyong transaction ni Coco Martin, pwede bang mag-object yung lawyer ni Coco Martin and say that the agreement is covered by the statute of frauds? So, in other words, is the defense of statute of frauds available to the defendant? Remember, class, here that the defense is not available because the agreement is not covered by the statute of frauds. Bakit? because it is to be performed within a year. Remember, today is August 27, 2020. The performance is December 5, 2020. So, sa totoo lang, hindi kailangan ng kahit na anong memorandum or writing to prove the existence of such an agreement between you and Coco Martin. So, kung pwedeng i-prove by oral or parole evidence yung existence ng contract, Coco Martin may become liable for damages. So, remember class that unenforceable contracts will be applicable only to actions for damages, and actions for specific performance applies only to executory contracts, not applicable anymore when the contract is admitted or there is failure to deny the existence by failure to object to the presentation of oral evidence. Also, emphasize ko lang, it is applicable only to the agreements enumerated therein. So, if this is not one of the if your agreement is not one of the agreements enumerated under the statute, hindi siya covered. Yan. Even if walang writing, it can be proven by oral evidence. This is based on the principle inclusio unius est exclusio alterius. What the law does not include, it excludes. Again, remember your Latin terms. So, kailangan ng Latin. Even if Latin is a dead language, remember, you have to learn the more popular terms. Huwag kayong mag-alala. Nalaman ko lang lahat yan nung hindi sa law school. Nung nagtuturo na ako ng business law. So, anyway, what else? Discuss pa natin yung mga ibang klase ng agreements covered. So, special promise to answer for the debt default or miscarriage of another. So, ito yung pagiging surety or guarantor. So, kung gusto mong maging guarantor, gusto mong maging surety, yung iba kasi surety Pero yung teacher ko sa partnership anyway, as if naman interesado kayo. Pero yung teacher ko na yun, pronounces it as surety. So, whatever floats your boat, class, kung saan kayo masayang pronunciation. So, in guarantee or surety, pagka mag-guarantor kayo or mag-surety kayo sa utang ng iba, you promise to pay their debt. Remember, class, that agreement must be in writing or else it is unenforceable against yung guarantor in quotes and also the surety. Kung wala kasing kasulatan, technically, they are not guarantors, they are not sureties. What else? Number 3, agreement made in consideration of marriage other than a mutual promise to marry. So, remember, these are agreements that will be entered into maybe by the husband or future husband, future wife. Pagka pinakasalan mo ko, ipagtatayo kita ng bahay. So, nung kinasal na kayo, siyempre, nainganyo siya dahil ipagtatayo mo siya ng bahay. So, pinakasalan ka niya. So, later on, hinahanap na niya yung bahay. Tapos, kung ikaw yung nag-promise, remember class that pwede mo siyang takasan. Why? Because it is not in writing. So, kailangan, pagka bibigyan kayo ng isang bagay, para pakasalan niyo yung isang tao, it should be in writing or else it is unenforceable kahit mag-demand na ka pa. So, anong gagawin mo dyan? Hiwalayan mo na lang siya, kasi hindi niya tinupad yung kanyang promise. Huwag kasi kayong uto-uto. Problema sa inyo So, anyway, remember that this does not talk about marriage settlements, yung natanong sa akin last time, or antenuptial agreements or prenuptial agreements. So, anyway, yung mga yun, kailangang isulat talaga yan. Kasi i-attach mo sa marriage contract yan para maging valid. But remember, hindi naman ito yung tinutukoy ng law. Kasi yung prenuptial agreement, tsaka yung or marriage settlement or antenuptial contracts, or they are the same animals They talk about the property relations of the wife and husband. The next kind of unenforceable contracts are agreements for the sale of goods, chattels. These refer to your personal properties or movable properties or things in action, otherwise known as your chose in action, or this refers to your right to sue at a price of not less than 500 pesos. So what you have to remember here is, if it is a sale of goods, chattels, or things in action, and the price is 500 or more, it needs to be in writing. So let us say an agreement class to sell a car worth 50,000 pesos. Tapos the sale is in 2 weeks. Tapos pagkatapos ng 2 weeks, the car is specific, let us say. After 2 weeks, yung buyer very excited to buy the car already. Tapos itong si seller, ayaw na niyang ibenta yung sasakyan niya. So anyway, class, remember, itong si buyer nagdemanda dahil nga gusto niyang bilhin yung sasakyan. So he goes to court para i-enforce yung contract. So the first obligation of the buyer is to prove yung existence ng agreement between supposed buyer and seller, to be buyer, to be seller. So anong gagamitin niya dahil wala siyang written agreement? Witnesses. But again here, class, hindi pwede ang verbal or oral evidence because this is an agreement covered by the statute of frauds. So ang tatanggapin lang ng korte na evidence to prove the existence of the agreement between buyer and seller, na meron talaga silang agreement to buy and to sell, is the written instrument, which in this case wala yung buyer. And also to add to that, class, remember, pagka naman nagkaroon na ng full performance ng contract, meaning the contract has been fully executed, there's already price paid, and there is already delivery of the object, remember, the contract is taken out of the coverage of the statute of frauds because of the full performance. Kahit na wala bang writing, na-deliver naman na. The contract has been satisfactorily concluded. So, remember, wala na sa, statute of frauds. What about if there is partial payment on the part of the buyer or partial delivery on the part of the seller? If there is partial performance, the contract is considered partially executed. Now, again, as I've already mentioned, partially executed contracts are not covered by the statute of frauds. So, kung mapapatunayan yung there's partial delivery on the part of the seller, partial payment on the part of the buyer, pwede na kayong mag-present ng verbal evidence to prove the existence of the contract. Anyway, it does not anymore fall under the statute of frauds. In case of sales made by auction, sufficient ng writing yung record sa sales book ng isang auctioneer, even if no payment has been made yet and no delivery has been made yet, the contract is enforceable as long as it is recorded in the sales book of the auctioneer. What if, class, ganito yung problem? Meron binebentang necklace. The value of the necklace is 450 pesos. Ngayon, itong 450 pesos na to, wala siyang writing. But but the sale is to be performed on December 5, 2021. So, later on December 5, 2021, dinedemand na ng buyer yung bracelet. Bracelet ba yung sinabi ko? Bracelet, sige. Dinedemand na ng buyer yung bracelet. So, question, class, pagka nagkaroon ng action in court, can the agreement between buyer and seller, in case the seller refuses to sell now after on the agreed date, pwede bang patunayan ng buyer yung existence ng contract by verbal evidence? So, remember here na kung titingnan mo yung number 4, it is not covered by the Statute of Frauds, the price being only 450 pesos. But remember also class here, hindi siya nalaglag sa number 4, pero nalaglag siya sa number 1. An agreement which is not to be performed within 1 year needs to be in writing. So again, the contract cannot be proven by parole evidence. So, yun ang mangyayari sa example na yan. What else? Also, agreement for leasing for a longer period than 1 year. So, kung mangungupahan kayo, pagka mahigit 1 taon yung iyong upa, there must be an agreement in writing na kayo ay mangungupahan within that certain amount of time para maging enforceable yan. So, kung later on wala kayong writing, tapos dinidemand yun na sa lessor na paupa na niya yung kanyang lupa o yung kanyang property, tapos tumanggi siya. Remember, kung more than 1 year yung kontrata tapos walang writing, you cannot prove the existence of the agreement by using verbal evidence. Also, sale of real property. So, kung nag-usap kayo na magbebentahan kayo ng lupa, buy and sell ng lupa, bibili si buyer, bebenta ni seller yung lupa na to, kung walang agreement in writing na merong bentahan na ganyan, remember, the contract is unenforceable. Now, what if, class, there is already payment of the parcel of land? Unenforceable pa ba kung sakaling walang kasulatan? Hindi na. If there is payment already, remember, full payment. Remember that the contract is taken out of the coverage of the Statute of Frauds because there is partial performance, the contract is partially executed. Ay, hindi. Full na pala yung payment dito. Oh. The contract is fully executed. So, remember, class here, taken out of the coverage of the Statute of Frauds. And even granted to the buyer is the right to compel the seller to execute the necessary document to allow transfer to the name of the buyer yung property. So, yun ang tandaan natin. Even in case of partial payment, partially executed contract, again, kung may bayad na yung lupa, down payment, etc., taken out of the coverage of the Statute of Frauds. And remember, it can be proven by oral evidence. What else? Representation as to the credit of a third person needs to be in writing. So you represent that he is solvent. So ngayon, kung hindi ito in writing, later on, wala naman palang credit itong third person na ito. Wala naman pala siyang pera pala. So remember, class, that later on, if yung creditor, dahil nagkaroon ng parang misrepresentation dito, the creditor cannot demand for damages kasi parang naloko siya. So, because your representation is not made in writing. So, yung representation mo must be made in writing to make you liable. Yan, kung sakaling hindi totoo yung representation mo. What else do you have to remember? The modes to ratify. Again, I've discussed this partially. Actually, not partially. Talagang na-discuss ko na to. Failure to object to the presentation of oral evidence to prove the contract. So, kung inalaw mo yung mga witnesses, tapos hindi ka nag-object, it is a waiver of the defense of Statute of Frauds. What else? Acceptance of benefits under the contract, not anymore executory. It is partially executed and the contract is taken out of the coverage of the Statute of Frauds, in which case, it can be proven by oral evidence. So, the last unenforceable contracts are yung contracts where there is incapacity on the part of both contracting parties. Dapat pala nilagay ko yung salitang both, contracting, both. Yan. Anyway, ratification. Remember, a contract entered into by incapacitated persons, both of them, may be ratified. Now, in 1407, there is ratification of an enforceable contract. And remember the rules here, dalawa siya. If the ratification is made on the part of only one of the parties, remember class, it becomes a voidable contract. And in number 2, if the ratification is made by both parties, the contract is valid and it retroacts to the time it was entered into. So the validity will date back, kasi retroact is pagbalik bumabalik siya at the time it was entered into. So remember, valid siya simula nung time na pinasukan mo yung contract, hindi nung time na ni-ratify, but it is valid at the time the contract was entered into. So that's it for unenforceable contracts. Please wait for our lecture on void contracts. It will be a longer lecture because the chapter for void contracts very long also. Thank you, class.